Hello, everyone. Welcome to this talk about human rights before and after environmental protection. My name is Peter Szigeti. I'm an assistant professor at the Faculty of Law at the University of Alberta. And it is my great pleasure to be able to welcome here online Marie-Catherine Petersmann, an assistant professorial research fellow at the London School of Economics, with whom we will be talking about environmental protection and the strange, sometimes fraught relationship that environmental protection, ecology, nature has with the concept of human rights and protections for human rights. Um, so a lot of what we will be talking about is Professor Petersmann's recent book called "When Environmental Protection and Human Rights Collide." Now, usually, of course, it's customary to show the book, but both me and the library, the University of Alberta Libraries, collects only ebooks. So it's a bit less impressive to show the PDF, but I did print out the cover of the book. So I do encourage everybody to read this wonderful book. Um, but we will touch on much of the research and much of the content, both within the book and all the research that inspired Professor Petersmann and myself. So first, let me, before proceeding, acknowledge where I am right now. So at the University of Alberta, we're on the traditional lands of the Dene, Ojibwe, Saulteaux, um, Blackfoot, Lakota Sioux, and Métis, and a meeting ground for many other Indigenous peoples. Um, Professor Petersmann, she will be joining us from London, and let me just introduce her before I start asking some questions. So she is an assistant professor at the London School of Economics. Previously, she was an assistant professor at Tilburg Law School in the Netherlands. She is the holder of a very prestigious grant from the Dutch Research Council called Anthropocene Legalities, Reconfiguring Legal Relations Within More Than Human Worlds. She has published this book and another book on rights to water in French, and numerous articles. And she's also an editor or a member of the editorial board of the Review of European Comparative and International Environmental Law, and also has been a research fellow in many places from Rome to Glasgow, and is just all around an amazing researcher. I'm very happy to be able to share the screen with her. Um, so hello, Marie, welcome.
Thanks so much, Peter. It's wonderful to be here. Thanks for this warm introduction.
So we thought of today's event as a conversation where we will both introduce the book, but range at two different topics beyond the book as well. And I guess my first question to you is, why is the environment important for human rights, as an introductory question? So we're seeing a lot of discussion this week about health, about development goals, about statelessness, about gender issues, all things that are incredibly important for human survival. Where does the environment actually enter the framework of human rights?
Yes, thank you, Peter. And after this warm introduction, I want to myself thank you first before responding to this question. Thank you for this very warm invitation to virtually inviting me to the University of Alberta to be in conversation with you today, and also thank Nadine and Angus, who are behind the screen facilitating this event. And as Peter mentioned, we've been in conversations many times thinking about ecology and law, and these conversations have really always been so inspiring. So I believe you are all really lucky to be taught by such a fascinating mind at the forefront of scholarship on law and ecology. Now, to your important question, Peter, about why the environment is important for human rights, I believe that a straightforward answer would be to just say that no human right could ever be fully realized in a generalized context of environmental pollution and ecological collapse. And I guess there is no need to repeat again and again the very daunting numbers and tragic indicators of biodiversity loss, the sixth mass extinction that we are going through, global warming, environmental toxicity, and all the other slow and sudden onset events such as droughts, mega fires, sea level rise, hurricanes, famines, and so on, that all bear really vital consequences on the enjoyment of human rights, be it the right to life, the right to health, the right to water and sanitation, the right to food, the right to adequate standards of living and family life, the right to enjoy one's culture, especially when it comes to native, Aboriginal, and Indigenous peoples around the globe, and mostly those living in what we call in the jargon small islands and developing states that are, of course, particularly vulnerable to climate change and its effects. And these rights are in many ways interdependent and somehow today captured also in the discourse on future generations' rights, which is also entangled with the necessity to protect and to care for the environment in order to ensure conditions of planetary inhabitability, as Achille Mbembe would put it. And so this mutually supportive relation between the protection of the environment on the one hand and the protection of human rights on the other hand has given rise to what I call in the book that you mentioned, a synergistic link between environmental and human rights protection. And this synergistic account between environmental protection and human rights was really key to raise awareness about environmental pollution in a vernacular of human rights, but it also led to negative side effects by framing and somehow enclosing environmental concerns in a human rights lens, with little attention paid to the numerous conflicts of norms that also underpin the relationship between environmental protection and human rights, and also little attention paid to the many ecological concerns that vastly exceed and cannot be accounted for in the human rights register. And I'm happy to expand on these tensions or these trade-offs later on, if you will.
So yes, I think there's a lot of things that we can go into depth in this in your overall answer. Before proceeding, I do want to mention the chance for the audience to submit questions. So as you can see on the screen, there is a Mentimeter code at the bottom. So if you go to menti.com and enter this 8-digit code 94673553, then you will be able to enter questions, which I can then read to Professor Petersmann off the Mentimeter screen. So feel free to submit questions at any time, and in the second half of this lunchtime talk, we will get to those questions. So Marie, at the beginning of your answer, you mentioned you started off by saying that human rights cannot exist without or in a state of environmental collapse. And there is no dispute that we are living in in this very dire situation of environmental collapse. Quite visible here in Alberta. Just a week ago, we had temperatures of plus 10 degrees in January in Alberta, so that's 20 to 30 degrees higher than what would be normal this time of year. Yet for decades and decades, if not centuries, this relationship was basically ignored in the human rights literature. So the title of this conversation, The Environment Before and After Human Rights, quite topical. We're here celebrating the 75th anniversary of the Universal Declaration, but even a cursory read-through shows that there is no mention whatsoever of the environment in the Universal Declaration. You can read into it a right to food, a right to shelter or housing. So what was thinking about the environment like in 1948, or let's say the extended period between 1930, 1950s, etc.?
Mm-hmm. Mm-hmm. Yeah, thanks for this question. And you're absolutely right. The environment is nowhere mentioned in the Universal Declaration of Human Rights. And this is also the case of other regional and international human rights instruments that were adopted shortly after the UDHR, such as the 1950 European Convention of Human Rights, where the environment is also not mentioned, as well as the 1966 International Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. And this absence or this silence, as you put it, speaks precisely to the fact that the awareness or the consciousness about the need to protect the environment emerged relatively late. And I'll not be able to do justice here to the history of environmental protection in international law in a couple of minutes, but what is important to bear in mind is that for much of the modern history in a Western context, the quote-unquote environment was legally regulated as a commodity, so as a natural resources that could be extracted, appropriated, and controlled for economic activities. And of course, this approach was itself embedded in a colonial history of European conquest, itself and then entangled with the transatlantic slave trade and the establishment of plantation economies that really rested, if you will, on a monocultural exploitation of non-humans, whether natural resources or lands, often those of dispossessed indigenous peoples, but also non-human beings like chattel slaves that were considered somehow less than or inhuman. And so this early legal regulation of the environment was mostly perceived the environment as an object of regulation for extractive economic purposes in the hands of powerful early capitalist, imperialist, and racist economies that saw nature or natural entities as dead matter that was turned into commodities. But at the same time, there was also another strand of early environmentalism that emerged throughout the 18th and 19th century, and which was embedded in a romantic aestheticization of nature, where there was really a sort of invocation of a pristine myth to create a recreational nature reserves, to preserve a sort of artificially constructed ideal of Eden, right? Away from always more industrialized and polluted urban centers. And this was precisely the time where many natural parks were created, starting with the Yellowstone and the Yosemite parks in the US in the late 19th century, in 1872 and 1890 respectively, but also, of course, the creation by the British colonial power of several game reserves in Kenya in 1904 on the land of the Maasai, resulting again in the forced eviction of these indigenous pastoralists from their ancestral lands. And so In the book, I therefore retrace how this early protection of the environment was therefore invoked by Western powers for different purposes throughout time. Economic ones on the one hand, conservation ones on the other hand. And I show that there was a veritable paradigm shift after the Second World War, when the moral vernacular of human rights started becoming prominent in international discourses, and taken together with a number of environmental disasters that really impacted the public opinion in Western societies, and which by that time was already globally connected somehow. And I'm thinking here about disasters like the 1959 mercury pollution in Japan that gave rise to what would later be coined the Minamata disease. So that was a neurological syndrome caused by very severe mercury poisoning through the consumption of polluted food and water. Another example was, of course, the publication of Rachel Carson's book Silent Spring in 1962, which really decried the widespread environmental damages caused by the pesticide DDT and the sort of vicious circle its use created for human health by penetrating the entire food chain. And other mobilizing factors were the Torrey Canyon oil spill in the North Sea, one of the world's most serious oil pollution accident to date, and which took place in the early 60s. And so just to give you some examples, these events really marked the collective traumas of Western societies and instigated a sort of environmental awareness that human activities must be controlled and regulated to preserve the environment in order to secure human life and health. And in these years, for the first time, the environment began to be conceived as a sort of sensitive, sort of defenseless ecosystem dependent upon human protection. And this idea that humans had to be stewards of nature was really instrumental in triggering this sort of alarmist human survivalist discourse, where the environment needed to be protected for the sake of human survival. And it is here, of course, that the power of human rights discourse provoked or was really key to mobilize for the protection of the environment. But as I mentioned earlier, from this perspective, rather than an end goal per se, the protection of the environment was here really presented as a necessity to achieve, in fine, a greater fulfillment of human rights.
Mm-hmm. So thank you for starting off with the property aspect. Of course, that's something that's very visible in the Universal Declaration and the other human rights instruments, where the assumption is that owners will be good stewards of their land, and therefore we don't really need extra protection. We just need ownership, because that will, based on self-interest, give rise to protection to begin with. And you also mentioned these early 60s environmental catastrophes and reactions to them, such as Rachel Carson's book. And as far as I know, the legislative reaction to that in the United States, the first developed country with explicit environmental laws, was basically, well, we'll make a few regulatory acts, the Clean Water Act, the Clean Air Act, and we'll have this solved in no time, 5-10 years, and we can forget about this problem. So when did environmental law enter human rights law as such? When and how did this become an international concern that required human rights courts and other courts' attention?
Yeah, that follows up very nicely from the sort of origin story of international environmental law that I just described and somehow critiqued, because you're absolutely right that environmental concerns were first and foremost dealt with at the domestic right level, within national jurisdictions. And it's only in the late 60s and 70s, or late 60s and early 70s, that the human rights discourse grew in popularity in Western societies, when Samuel Moyn famously said that a genuine social movement around human rights made its appearance, right? And as I said, the human rights grammar was useful to generate greater mobilization in reaction to environmental calamities. And so it's in 1968 that we find the first, if you will, connection between environmental protection and international human rights approaches. And it's in a resolution that is titled Problems of the Human Environment. And I want to stress that the name of the resolution is indeed indicative here of the overall instrumental and anthropocentric approach that I described, by reducing precisely the scope of concerns to the human environment. And so with this resolution, the UN General Assembly adopted this text and underscored for the first time the positive correlation between environmental protection and what in the resolution is said to be the condition of man, his physical, mental, and social well-being, his dignity, and his enjoyment of basic human rights. And I want to stress that this gender terminology is, of course, not mine, but from the resolution itself. But interestingly, during the plenary meeting of the UN General Assembly at which this resolution was adopted, member states decided to convene the first the first of a series of major global conferences on environmental protection under the auspice of the UN. And the Stockholm Conference on the Human Environment was to be held in 1972 and planned, as per the resolution, to put environmental protection at the center of human concerns. And of course, in reality, and if you allow me a touch of cynicism, it was, of course, human interests that were put at the center of environmental concerns. Because, again, the environment at stake here is that of human beings, and any environmental interest not directly related to human concerns would fall outside the scope of the Stockholm Conference. And we would have to wait 20 years until 1992, for example, for the Convention of Biological Diversity to see the day. Now, in the run-up to the Stockholm Conference in the 1960s, former colonized states were really gaining their independence from imperial powers and started expressing their own, and at times, of course, divergent concerns against Western agendas, including in relation to socio-ecological concerns. And several states from the global south warned indeed against a coupling of environmental with social and economic development, and emphasized really the need to prioritize the social and economic components of their development rather than focusing first on environmental policies, which was at that time considered a sort of luxury of the rich, if you will. And to convince developing states to participate in the quote-unquote global battle for environmental protection and not to boycott the Stockholm Conference, as countries like Brazil were calling for, several compromises were struck to again ensure this sort of global agenda for the protection of the human environment. And for example, to temper the resistance from newly independent states, it was decided to tactically frame the notion of development not as a cause of environmental pollution, but as a cure for major environmental problems. And so there was a related promise of financial counterparts from developed countries that would secure the participation and the commitment of developing states that was set in motion in this sort of global environmental governance model, where countries of the global north reluctantly contributed to financial aid, compensation for environmental loss and damages, technological assistance, capacity building, and so on. But of course, what's important to emphasize is that global north states accepted, if you will, to operationalize this concept of what would later become the common but differentiated responsibility, CBDR, and did so more on the basis of differential or superior capacity rather than as an indication of state responsibility for historical harms related to the colonial plunder of the environment and global south states. Now, to briefly come back to the Stockholm Declaration on the Human Environment, this is often lauded in the literature as really the first successful global intergovernmental negotiation process leading to the recognition of environmental protection and human rights in the international law arena. And I stress intergovernmental because there had already been earlier non-governmental initiatives that recognize the need to protect the environment. And this we see, for example, the creation in 1948, the same year as the UDHR was adopted, of the International Union for the Conservation of Nature, the IUCN. Now, because the Stockholm Declaration is so important in the history of environmental human rights, I still want to just add two important elements. The first one is that the Stockholm Declaration was indeed the first instrument that established this explicit link between human rights and environmental protection, with its principle one that states, and I quote here, "Man has the fundamental right to freedom, equality, and adequate conditions of life, and an environment of quality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations." And so with the quality of the environment that is now framed as a precondition for the fulfillment of the right to life and to health, the first seeds of a human rights-based approach to environmental protection was planted, paving the way here for this legally integrated and synergistic approach that I mentioned earlier. And from the Stockholm Declaration onwards, all future international environmental instruments, the 1992 Rio Declaration on Environment and Development, the Convention on Biological Diversity, or the UN Framework Convention on Climate Change, they would all explicitly recognize and reassert the need to protect the environment in order to secure human rights. Now, simultaneously, human rights instruments adopted after 1972 also started to explicitly refer to the protection of the environment. And we see that in Article 24 of the African Charter on Human and People's Rights, also in the Protocol of San Salvador to the American Convention, the Arab Charter on Human Rights. Anyway, all these different regional and international instruments adopted after 1972, with the only exception being the European Convention on Human Rights, which is also the only instrument adopted prior to 1972. And now, very briefly, the second point I wanted to mention relating to the Stockholm Declaration is that this is not a legally binding instrument. And despite this soft law nature, its influence was really key in the development of both international environmental law and international human rights law. But as of today, a standalone, legally binding and justiciable right to a healthy environment has not yet been recognized in international law. And I think that's important to stress.
So that's definitely something we can and probably should get back to. But one point I want to focus on, and it seems the audience also wants to focus on, is so this post-1972 understanding as the environment on the one hand key for human health, and on the other hand key for human development, and that we need to have some sort of balance or trade-off, or in any case a sort of intermingling between health and development, and leaving nature alone, I guess. So let me read some of the questions. Somebody asks, what are the practical implications of the presenter's theoretical arguments? How would she suggest states produce policy which balances human rights and environmental concerns? So this viewer thinks of a balance as sort of the starting point of all environmental protection. And someone else wrote, what if a government chose to take down trees and deforest in order to build more infrastructure, citing the need to develop the country? So even before we started talking about that, again, some people immediately came to the opposition between development and the environment. Now, as far as I know, you are quite critical of this anthropocentric approach, but maybe there's more to it. So can you tell us about what's missing from this balancing approach and from the anthropocentric approach of we need to protect the environment in order to secure health, safety, security for humans?
Yeah, thank you. And I think these are indeed very important questions, because I think there is no way out of this conundrum, in the sense that there is this question of balancing is inherent to any human activity. Any human action is always a matter of balancing what is done from an anthropocentric perspective in order for the benefit of human activities, human health, human rights, etc., and the impact it bears on the environment. There is no pure, if you will, human activity, human way of life that cannot bear impacts on the environment. And so this is precisely the sort of tension that I'm trying to navigate with in the book. And so I guess my point is not necessarily one in response to the first question that you asked, or that a member of the audience asked, about what is missing from this balancing exercise. So in the book, I really try to analyze very carefully how regional human rights courts precisely deal with this trade-off, this balancing, right? And we are aware, of course, that there is this technique that is referred to as balancing and proportionality test that tells us a lot about how adjudicators are supposed to handle these conflicts of norms, right? But in reality, they are dealing with tensions that are intrinsically indeterminate in nature. And so this balancing act becomes basically a matter of prioritizing certain relationships between the human concerns and the ecological concerns that are at stake. And so I think a critique that underpins the whole project lies perhaps in how this human rights-based approach to environmental protection, of which I traced the origins in the first part of this conversation, what consequence it bared on how we can make sense or not make sense of ecological relations or ecological dynamisms, if you will, through our legal systems, through our legal concepts, through our legal practices. And I think one very common critique is indeed to refer to this disconnection, this sort of separation that this human rights-based approach to environmental protection has somehow performed by establishing a sort of prioritization of human concerns over the environment, right? That is one dimension of the anthropocentric critique that is quite prominent. And so there is, of course, in my current project, I draw a lot on different strands of theory and of practice that think with what is commonly referred to as post-humanist understanding or post-humanist approach, where we think about what is often referred to as more than human world. So thinking about how humans relate to the non-human, not from this modernist understanding and sort of liberal understanding of autonomous humans separated from non-humans, right? But from this sort of entangled understanding of humans and non-humans against the backdrop of more than human worlds. And I emphasize here the plurality of worlds to insist that there is no singular world that exists, thereby countering also this Eurocentric and colonialist enterprise that started with these great discoveries and was fueled, if you will, by the Enlightenment period to globally impose a homogenized model of living through colonialist conquest of lands and of people. But I also want to emphasize the more than human that really actively decenters the category of the liberal, autonomous, rational, and free human subject to start instead from a sort of dehumanist approach to living, where so-called human interests are intrinsically bound to and interdependent from those of non-humans. And so I think this is something that there is no easy answer to that difficult question, but perhaps in decentering a bit or problematizing at least the origins and consequences of this anthropocentric understanding and nature of our legal ordering of the non-human world, there can be something important at stake.
Mm-hmm. So I'm going to jump in and follow up on this. Can you tell us an example of where a post-human approach would bring a marked difference? Like, do you have a favorite case which might have been wrongly decided by a court or rightly decided, but still shows the limits of this anthropocentric approach, where a post-human, more than human approach would bring a visible difference?
Yeah, so I don't have necessarily a favorite go-to example, although I have a sort of soft spot for an example that I draw from EU conservation law, but I know that you are also familiar with this strand of law, Peter, and especially in relation to animal agency and animal mobility. And so I like to think with, I will use two examples. The first one is this example from EU conservation law, where instead of, now there is this sort of very prominent discourse about granting rights to nature, which has become a bit the sort of second wave of mainstreamed rights-based approaches to environmental protection, now extended from the human to the non-human, right? Where we grant this sort of legal subjectivity or personhood to non-humans, etc. And I think there is a problem, we can come back to that, but there is a problem in this approach in the sense that it reinscribes and reinforces perhaps even this sort of disconnect that I mentioned earlier, cutting ecological processes that are cyclical in nature, that are dynamic, etc., by insisting on the autonomy, right, the individuation of particular ecological processes that ought to be granted legal personhood or legal subjectivity to be protected as such, right, in their individuated autonomous capacity. And so this is a bit where the sort of progressive discourse of post-human scholarship goes to, right? And in my opinion, because of the problems I mentioned, I much rather I prefer thinking with other examples of ecological responses to non-human agency. And just to give you an example of how wolves have been protected under EU law today, where as an endangered species, I don't know if this is also something that has reached or perhaps even predated the European practice in Canada, but the reintroduction of endangered species, the wolf being a sort of canonical example in this regard. So wolves have been reintroduced in several different European countries, and the legal protection that has been set in place is that instead of protecting the territory of the wolf, right, thereby reinscribing a sort of jurisdictional or territorial delimitation, if you will, of the habitat of the wolf, the legal protection of the wolf follows the movement of the species, which means that if the wolf is on the move and crosses, whether it is a territorial boundary or a jurisdictional boundary of the protected area that has been granted this sort of heightened legal status of protection, well, the legal status of protection actually moves with the wolves and follows the wolf, even if the wolf would end up in an urbanized setting, for example. And this raises then a lot of different problems that are very interesting to follow. For example, the construction of wildlife infrastructures above or intermingled with human infrastructures like highways, etc. But this is an example where I think from a post-humanist perspective, it is really the legal reflection starts from the agency and the interest of the wolf rather than the other way around. And we are not trying to statically protect the wolf as an object, almost like imposing a sort of immobility to his protected status. But there is a sense of relational dynamism that has been inscribed in the legal regulation at hand. The second example I wanted to mention relates to indigenous cosmologies that have been translated in many legal settings. Of course, not international ones, although this is emerging also. I know that at the EU level, there is a very strong movement to recognize, based on the inspirations of indigenous cosmologies, again, this sort of move to granting rights of nature, etc. But I'm happy to discuss more about that if it's of interest.
So that's actually great that you brought up indigenous cosmologies, because both reconciliation, political reconciliation between indigenous nations and settlers and the Canadian government, and of course the colonial legacy in Canada is extremely important, and especially here in Western Canada, and some of the viewers actually asked questions about this, so I guess now is a great time for me to ask them. One of the questions is, as settlers, how can we balance considerations for Indigenous sovereignty with environmental concerns? Another person actually brought up whether human rights conventions are the right path, and Ecuador's constitutional amendment, the rivers in India, the Martuara in Australia, all of these require a government willing to enforce and support these. So I guess I can more generally say that or ask, what is the role of Indigenous peoples in protecting the environment, or in the frame of human rights, or the right to the environment? How, or let's keep it a bit more specific to courts and to judgments, and then maybe we can talk a bit about policy as well. But so far, how have courts reacted to Indigenous peoples' claims to the environment and their cosmologies and their approach to the environment?
Yeah, thank you. Again, that's such a vast question, and I think from the analysis, I mean, in the book, I really focus on regional human rights courts and have focused also strongly on the environmental jurisprudence of these regional human rights courts that deal with indigenous rights, and this is mostly in the context of the Inter-American Court and Commission and the African Court and Commission on Human and People's Rights. The European Court on Human Rights also has a sort of very small environmental jurisprudence relating to indigenous peoples, notably the Sami people. But here there have very often been problems of standing leading to the inadmissibility of the cases. And this is one element that I think is important to perhaps begin the conversation with, that there is already at the onset a difficulty in reconciling, if you will, the recourse to courts, regional human rights courts, by indigenous peoples, when there is not a recognition of collective claims that are guaranteed for standing. So you might be familiar that there is this necessity to recognize or to fulfill the victim status for a case to be fulfilled before, to be admitted before regional human rights courts. And of course, this is often on an individual basis, right? The alleged victim of a human right will claim that their right to life, to health, to family life, or whatever, has been violated through the environmental impact harm of that has been caused by a specific perpetrator. And so when it comes to indigenous peoples, the claims are often of such a sort of collective nature that vastly exceed these individuated rights frameworks that somehow enclose the very system of rights-based approaches to environmental protection, that there are lots of issues of standing that need to be addressed. Now, I don't have time to speak about that in detail, but there are lots of different procedural hurdles that must be mentioned when it comes to environmental cases before courts, relating to the question of attribution and causality between the environmental harm and the victims. But in relation to the question of indigenous people's right, both the Inter-American and the African human rights mechanisms have proven to be quite creative and generous in recognizing the collective claims of indigenous peoples. And so in one way, you could say that rights-based approaches have proved particularly useful for indigenous peoples in recognizing their collective claims to ancestral lands, their right to their traditional culture, many other rights that were successfully protected through courts proceeding, right? But at the same time, there is a sort of, and this is part of the problems I identify in my research by looking at very particular cases, there is a sort of lingering essentialization that also comes with these proceedings, where indigenous peoples are often reduced somehow to an understanding, an interpretation, almost a contestation of their very being, that becomes a sort of site of contestation about whether this being is still traditional enough or whether it has to become too modern, right? Thereby excluding them from special human rights schemes that they enjoy, be it the right to prior and informed consent, being the right to indeed collective land claims on their ancestral lands, etc., etc. And so I think there is really a slippery slope here in terms of essentializing indigenous knowledge, indigenous way of being, reducing them to a sort of repressive authenticity when invoking generalized modes of indigenous being, indigenous ontologies as the solution to the ecological problems we face. And this is a risk that I think is really very often reproduced in courts, and that we ought to be attentive to.
So this is very interesting. This sort of, I guess, the indigenous as also a quote unquote species to be preserved in its quote unquote natural environment. Well, we're almost at the end of our time. I wanted to pose one more question, harking back to the recognition of animals and more than human worlds. One audience member asked, how would you make sure that the environmental choices are good? In Montana, I believe, or they believe, they reintroduced wolves to the environment, but it had very bad effects. The deer species was decimated along with others. So my sort of preliminary answer to that is that the moment we think about reintroductions, recognition of animals, what we're doing seems like a domestication of the entire environment, right? So now we're responsible for the wolves, for the deer. We have to sort of treat them the way we treat pets, make sure that they're all happy and get along, so to speak. But of course, that's just my first reaction. What would you say to these sorts of concerns?
Yeah, I think it links back to the very first question you asked, or a member of the audience asked, about this notion of balancing, right? We are back with this question of balancing different interests, and here also beyond indeed anthropocentric human interest between different species, and there is this sort of constant dealing with a sort of biopolitical or necropolitical dimension where we have to think about modes of governance that have very fundamental impacts on decisions about who has the right to live and who has to be sacrificed therefore. And this concerns not only human species and of course we know that vulnerable and marginalized racialized populations are often those human species, those part of the human species who tend to be sacrificed first. But this is also the case in the animal realm, where a lot of decisions have impact on prioritizing certain non-human species' life against others. So I guess we are back with this question of balancing that is absolutely fundamental, and there is no way out of it.
Well, I definitely don't have anything better or more to say about that. Do we have any last words that we want to speak at this point about human rights and the environment?
Is this a question addressed to me?
Well, I guess so. Yeah.
Yeah, I'm not sure if the audience is able to take the floor. I would have loved to communicate more directly with the audience. I mean, I would have a million things I would like to add and continue the conversation. It's always difficult questions that are posed, but really fundamentally somehow existential questions too. And yeah, I'm just very, if I have to have the last word, then it's just a word of thanks. I know that people are very busy at this period of the semester, the term. So I'm very grateful for your time, your presence, and all your wonderful engagement. And yeah, thank you, Peter. Thank you, everyone, for being here.
Well, and in that case, I would like to thank you for making time for us. I know it's already evening time in London, and you've had a very hard day. So I'm very grateful for this conversation and the opportunity to host you here. And let's keep reading and talking.
Wonderful. That's always the best way out. Let's keep reading. Okay. Thank you so much.